welcoming to the floor Mr. Elio de Tullio, the expert from China IP SME Helpdesk. Thank you very much.
I'm presenting on behalf of the EU China IP SME Helpdesk. I'm one of the external experts. This project has been established in 2008, and its aim is to assist small and medium-sized enterprises in protecting their IP rights in China. So basically, at the end, I have some slides about the activities of the help desk. Basically, are information, trainings, and assistance to SMEs, even through a helpline. So I have a different approach compared to what I've heard until now, because our perspective is really a bottom-up approach. So we really work on SMEs. My professional experience is I'm a lawyer, I'm an attorney at law, I'm the founder and managing partner of an IP firm, a tech law IP firm. So basically dealing with patents, trademarks, designs, copyrights. And I would say that intellectual property is a medium-long run project. So it helps small and medium-sized enterprises to, let's say, to protect their treasures when they are new, they are, they deserve protection. And usually it's a medium-long term because the protection lasts potentially unlimited in case of trademarks, 20 years in case of patents, 15 years in case of designs, and this is also valid for China. So, I mean, I would say that EU SMEs are quite optimistic, so they invest money in protecting their IPRs, despite of the situation. So they look at and they hope in a better future, probably. And so our perspective as, let's say, those who work on the ground is quite optimistic. EU SMEs do protect their IP rights. So if we look at the title of our panel, Digital Transformation, Technology and Data Security, I would say that I will focus on the first points because not all data are qualified, can be qualified as IP rights, but only those who meet the legal requirements provided for by the law. So as they can be protected through trade secrets, know-how, but we will focus in particular on digital transformation, so those who are investing money in protecting invention that are, let's say, the fundamentals of digital transformation, and also technology and technology transfer. So from the these are two slides just to make you be aware about what SMEs should think about before starting the IP path and in order to manage the intellectual property. So basically, what is, let's say, the best practice is to perform searches, consult database. We have a very high-level database, even free database. There is a SPASnet. Other database can be consulted independently. But through this database, you can understand where the world is going, and even the Chinese world. This database can also make you understand how, to what extent, you are free to operate in China. And then the second part, I mean, the other 7 boxes are related to IP protection. And usually the best practice for EU SMEs is to start protection from the country of origin or the region of origin. So for EU SMEs, the protection shall start in European Union. Of course, I can, let's say, explode these boxes, and I will spend a lot of time, but I will not do that because we are running out of time. Then the intellectual property can be used also in a dynamic way. So once you have a portfolio, then you can carry out an IP valuation and evaluation on quantitative and qualitative point of view in order to use your IP portfolio as a collateral for requesting a loan or for requesting a financial support or even for attracting investors. You can, let's say, receive a report helping you to promote your capacity to certify the quality of your research and development activities. But if we put together AI and patents, because basically AI tools are based on patents, so we can see that China has become the world's top holder of AI patents, holding 1.5 times patents more than all other countries. And according to the data presented by CNIPA, the China National Intellectual Property Administration, China now accounts for 60% of global AI patents. So if we have a look at the WIPO, the World Intellectual Property Organization figures, we can see that the number of global generative AI patents is about 14,000, which is, let's say, much more than in the other decades. And the leading companies are Chinese. So we are talking about Tencent, Baidu, and Alibaba. And probably we should think about intellectual property in a different way. The first time I was in, one of the first time I was in China, so more than 10 years ago, I visited the Baidu head office. And when you get into the, let's say, the office, you can see, let's say, a wall of 100 meters with silver plates engraved with all the numbers of the patents. And so Chinese companies are, let's say, proud, and they would like to be considered IP generating companies, generating, let's say, entities. And this is also included in the 5 years Chinese plan, 2021-2025, that was, whose report was presented just a few months ago, and stressing the fact that the Chinese government would like to, let's say, overcome the, let's say, the approach of IP users, and would like to become IP leaders. And this is very important because the change of approach will be reflected in the next 5 years plan. If we speak about AI, we cannot, let's say, exclude from the discussion the most popular products that we know. I mean, probably we use every day, ChatGPT and Gemini, both developed by OpenAI and Google DeepMind. So OpenAI owns about 50 patent families, so 100 patents, and Google DeepMind, 20 patent families, so 2,200 patents, and have filed several patents applications and, let's say, trying to protect the AI technologies, so methods for detecting and mitigating hate speech using language model. This is the title of a patent. Training with weakly supervised data and iterative text editing techniques, applications involving speech recognition and improvements in human-computer interaction, neural networks, so architectures basically, and advanced reinforcement learning, model optimization, multimodal architectures. So this is what we know. And they have been, let's say, for some parts, they have been used in some products. Tencent holds over 26,000 patents on several aspects of AI. Probably they are bigger companies. They use AI in several, let's say, tools. We don't know if they use this AI in all tools. And Baidu has surpassed 27,000 published AI patents application worldwide. So we are talking about totally different numbers, huge numbers. And let's say that the number of patents of Tencent is very high, going through machine learning, distributed learning, computer vision, gaming AI, 3D simulation, and you can see from this this graphic that it's increasing, even though in the last year there was a little decreasing. And as to Baidu, also they developed and they filed patent application regarding deep learning patent applications, and they are, let's say, leading the market right now. They are, let's say, they've started as search engine, and now they developed technologies in AI related tools. And this is the evolution of the number of applications of Baidu. So, lastly, I would like to stress some few, let's say updates. Once again, the Chinese government is investing a lot on intellectual property. For European Union SMEs, the Chinese market is a safe market, provided that they implement an IP strategy before filing the applications. So carrying out state-of-art searches, being supported by experts, assessing the legal requirements, and this, of course, is pretty much connected with the titled IP rights, so patents, trademarks, design. As to untitled IP rights, so know-how, trade secrets, copyrights, I would say that the best is always to be protected through agreements, contracts. In China, for instance, you can use evoluted and upgraded version of non-disclosure agreements called NNN, non-disclosure, non-use, non-circumvention. Of course, they have to be, let's say, written in a certain way, and they should be, let's say, validated by Chinese IP attorneys, and they can be, in this case, enforced before Chinese courts. But let's say the updates of the China patent law are basically related to these revised guidelines for patent examination for artificial intelligence. They have been, they will become effective on January 1st, 2026, and have introduced some key updates on procedural clarity, AI invention guidelines, streamlined examination, with major changes, including new rules for AI inventors, new tech and public interest, and other things. So, for instance, for AI and inventorship, CNIPA, the Chinese National Intellectual Property Administration, clarified that only natural persons can be inventors, not AI systems. Basically what it is also valid in Europe, and released guidelines for AI-related inventions. The examination guidelines, some revision about new plant varieties, and then new rules, I would say new guidelines to improve the quality of examination of design patents, patent evaluation reports. I will focus a little bit more about this. Crackdown of abnormal application, process efficiency, and revision of dual filing. These are very technical things, but this is just to show you that the Chinese government is, I would say, is investing a lot on human resources and technological resources to improve the quality of the IP rights for their companies, and also for helping them to, let's say, be on the safe side of the barricade when they go abroad. For instance, dual filing is let's say, was very popular because it allowed to file at the same time, simultaneously, patent application and utility model application. And now, I mean, things are changing. So if the applicant files a declaration for dual filing, according to what it is valid now, they can overcome double patenting by amending the invention claim, abandoning the granted utility model, and now, starting from January 1st, 2026, things are going to change. And so in case of declared dual filings, the applicant will be forced to opt and to choose one of the two, so abandon utility model or abandon the invention patent. I will not go through these technical aspects because they are very, let's say, IP attorneys, but it's important that you take away the message that the Chinese government is continuously trying to improve the quality of examination, helping IP filers, foreign IP filers, and also national IP filers. Of course, even enforcement of IP rights is strictly connected with IP, let's say, protection. You have, as you probably can remember from the first slide, you can use several IP enforcement strategies and several IP enforcement tools in China: administrative, customs, civil, criminal, etc. So it's quite interesting if you have performed properly the activities at the very beginning. And the other is the new Supreme People's Court interpretation of patent evaluation reports. So the key message, without going into details about this, is this patent evaluation reports that is used in utility model and design patent infringement cases, provided that designs and utility models are not submitted to a substantive examination in China. So this patent evaluation reports, it's an important evidence, but the Supreme Court said that are not a prerequisite for filing lawsuit and not necessary for determining validity. They can be requested by courts or enforcement authorities, but also voluntarily by patent owners, interested parties, alleged infringers. And I mean, this is also important because according to the previous practice, it was considered quite, let's say, a necessary condition to determining validity and filing lawsuit. So this is the end. I will leave you with these takeaway messages. Of course, the takeaway messages are basically those that we share as IP Helpdesk at the end of our presentations, are just tips in order to help SMEs to better protect their IP rights before starting any action. And these are the so questions. You can send questions to the helpline. It's free, fast, and confidential. The answer will be received in 3 working days. This is the helpdesk in a nutshell. And here you have the free of charge services of the IP Helpdesk. Stay connected. Thank you very much.